Welcome to For the Record with Greenwood Law.
Welcome to For the Record with Greenwood Law. Attorney Dylan Greenwood is the founder of Greenwood Law in Winston-Salem, North Carolina. Dylan is a criminal defense attorney representing clients in both state and federal courts, known for his high-level, personalized representation and hands-on approach to every case. I'm Lisa Mosby, and today we're talking about how self-defense actually works under North Carolina law and why the real rules are often very different from what people assume. Welcome, Dylan. Thanks for being with me.
Thank you for having me, and you cannot be more correct.
People often think self-defense is as simple as saying, I felt threatened. Under North Carolina law, what does someone actually have to prove before that claim even is considered?
Or I'll do you one better. We get people are like, this person stepped on my property. So of course I get to do whatever I want. You're like, no, you do not. A simple trespass is not enough. Self-defense is an incredibly nuanced aspect of criminal law, perhaps one of the most. There is a common law right to self-defense. There's a statutory right to self-defense. There are other statutory rights to self-defense that people know of as stand your ground, and within that, there's like castle doctrine related stuff. It is not enough in any way, shape, or form to feel just threatened. The way you look at it traditionally through common law, so the way the law recognized it before it was codified into a formal statute, was that basically you had to have necessity, you had to have proportionality, and there had to be fault. So basically you had to use force that was a reasonable amount of force. It was reasonably necessary to prevent the harm. And then the force had to be proportional to whatever that perceived harm was. So if somebody's coming at you with a fist, you can't use a deadly weapon in return. And then on top of that, there can't be fault in the conflict. So you, in essence, it's kind of really simplifying it, but you can't be the one to necessarily start the fight.
Interesting. How does the state evaluate whether someone's belief of danger was reasonable, and what kind of facts typically matter most in the analysis of that?
So there can be facts that relate directly to the interaction that two people have. There can also be facts surrounding it. So were there ongoing threats that somebody was sending out against somebody? I've seen cases like that where, for days leading up to whatever interaction they had, they say, listen, I'm gonna do something very harmful to you, something very serious. I don't like you for whatever reason, so I'm going to come and find you and do that. That puts somebody in a very threatened position. You're on heightened alert. That's a little bit different than just going about day-to-day life. But then there are also those pieces of direct evidence where the state looks at, or myself as a defense attorney look at, which are, was another individual holding a weapon? Did they have access to a weapon? Were they on their way to get a weapon? That's a biggie. Another thing you can look for is specialized training. Someone had specialized training that the other person was aware of. So let's say like you were in a potential fight with like a Green Beret or something, and you knew that they had specialized training. I'm not saying that it's absolutely justified in any way, shape, or form, and it would be a case-by-case basis. But the fact that they had different training than you could play into an analysis of what you are able to do reasonably under the law. So there's a lot of, when I say it's nuanced, there are a lot of big, big nuances.
I think that a lot of confusion comes from the difference between standing your ground, defending your home, and defending others. How do those concepts differ under North Carolina law?
Yeah, so you are able to defend someone else just like you defend yourself. And the analysis is the same. So you have to look for, was it allowable? What was going on? That sort of thing. And the stand your ground law is a statute that we put into place. I think it was back in like 2011, I want to say, that North Carolina recognized stand your ground. But what that does is it allows somebody to use deadly force to defend themselves or another. If somebody is coming into your home, your vehicle, or your workplace, and you don't have a duty to retreat. So there's a lot of states that require you to retreat first before you're ever able to use deadly force. It's not the case with stand your ground. It's kind of inherent in the title, right? But the key there is that you reasonably believe that the force is necessary to prevent great bodily harm or imminent death to yourself or to someone else you're protecting. So you're still analyzing some form of proportionality here. It's not just that, like I started this off, and somebody steps on your property and trespasses. That's not enough to use deadly force. Now, if they break into your home with a gun, I'm not saying 100% for sure, but that's probably going to be allowed for you to be able to enable and use what's called the castle doctrine, which is an aspect of that stand your ground law that we call it that because it's specific to your home. And you've got to, like I said, you've got to be able to show that imminent threat of danger. You've also got to look at whether or not, perhaps somebody's committing a forcible felony. That can be an inherent dangerous aspect. And if that's occurring, then yes, that might be allowed to use self-defense in a stand your ground or castle doctrine type area.
Yeah, I'm curious, when a case involves firearms, knives, or other kinds of weapons, what tends to change in how prosecutors or investigators look at that self-defense claim?
I would say that the scrutiny intensifies because the stakes are significantly higher. So whether that be, really thoroughly looking into the background leading up to the interaction, that being one of them, what someone else may have had in their possession or access to. You've also got whether or not somebody was intoxicated in some way. Did sobriety or lack thereof affect the decision making there? Every bit of that wraps up into how prosecutors assess. And I would say that more than anything, it's just a significantly heightened scrutiny in which you're looking at, because the stakes, and I mean, there's been a fair amount of gun related activity in and around this area of North Carolina. And I know it's a focus among all district attorneys' offices around this area and in the middle district of North Carolina to do something about it. So they're going to be looking at where a deadly weapon came from. How did you get access to that? How did someone else get access to what they had? Is there anything gang related here? Is it a situation where there's interest among, like, a romantic interest that's surrounding the whole thing? I mean, there's any number of aspects that play into that.
On top of that, self-defense isn't just about what happens in the heat of the moment. It often comes down to the evidence that it's available afterward. What type of evidence are most important, or pieces of evidence are most important in these cases?
So I've been involved in cases where you're looking at trajectory of projectiles. That's one thing. You're looking at injuries that someone may have. The person who, maybe exercised what they thought was self-defense, and whether or not that was valid, that's going to be determined. But, what injuries did they have? Sometimes you look at size differences. That can be a thing. You're looking at also too where stuff was positioned, located. Pictures become increasingly important. Videos become increasingly important. outside witnesses become increasingly important. And that's why a lot of times in cases involving something like this, especially the use of deadly force, outside investigators are almost always pulled in to try to figure out, are there different avenues to go down to try to flesh those issues out, because you don't want to leave any stone unturned. And that's really from the state's perspective and from the defense's perspective, because sometimes you can find something that'll, turn a case one way or the other. And that, obviously that matters for somebody's future.
Sure. We can
The other
drive
thing, I will add this: even if those investigators don't find something to potentially absolve somebody, there's still something called imperfect self-defense, where maybe the use of force wasn't congruent with whatever interaction was going on. It wasn't proportional. Investigation can help flesh out maybe the fact that, yeah, self-defense was valid in one sense. You had the right to defend yourself. You just went too far. And that can be enough to mitigate something that would be first, second degree murder down to, like a voluntary manslaughter. And you're looking at a massive difference in potential liability for years in prison. That's taking off decades or more. So, stuff like that matters.
Sure. We always ask you for an example, an anonymous example from your years of experience. Are there facts that can initially be misunderstood, but, at closer examination, it reveals that the situation was actually consistent with the law and with self-defense? Do you have a case that comes to mind at all?
When I think about my most recent self-defense case, my biggest recent self-defense case, stuff that kind of came to light after the fact that really kind of pushed the case one way or the other were medical issues that each person had. So for instance, like somebody had an injury that the other person didn't know about. Another person had perhaps like prior mental health issues that were known about. And all that stuff has to be fleshed out because it's all relevant. And you're not trying to, embarrass someone or put somebody out there or air all their dirty laundry. But if, you've got an individual who's used force in a way to defend themselves and they're aware of someone else's aggressive tendencies, that matters. That matters a lot. And if that stuff can come in, or you can figure out a way for it to come in, that makes a big difference. Plus, there can be situations where, for whatever reason, investigators don't take notes of certain stuff. So like the case I had, we got hired right away, went in to meet this person right away in jail. And I looked at this individual's face and I was like, I know you were in a fight, but, my gosh, what's going on? I was like, did investigators take pictures of your face? And like, no. So what do you think I did? I immediately started taking pictures of his face. Well, you know what happened when we're about to resolve this case and we're trying to push it over the edge for what we felt like was a reasonable outcome in the case. Prosecutor had no idea that this person's face was that messed up. And I had those pictures, and you know what? I was able to tip it over the edge just because, we thought in that moment, got to get that info because it might come up later. Sure enough, it did.
Yeah. We talked about the physical aspect of it, but how do statements made either to the police or at the scene in general, or even later, how do those statements affect whether someone's claim of self-defense holds up?
Sure. Statements always matter because we've all heard the moniker, right? Anything you can say will be used against you in a court of law, and that's true. And if you're not arrested, you're not being interrogated, and you're just saying stuff, then an officer has the ability to record that. A lot of times they're wearing body camera and they can get footage of it. They're making reports of it, or they're witnessing it, they're hearing it, and then they can potentially go to a hearing or a trial and talk about what you said, because it's no longer, it's an exception to hearsay at that point. An admission by a party opponent is one of those exceptions, and they can talk about what you said. So when they say that, anything you say can and will be used against you, that is absolutely true. And statements about your mindset are huge. Statements about what you're admitting to doing are huge. Anything related to those details. That's why, more often than not, it is very important for somebody to exercise their constitutional right to not say anything. That is typically the safest thing. And then let the other stuff come out as it can through other means that are not the defendant or the accused.
Yeah, zip it. It's not a place to be discussing your feelings, your emotions, or anything of that nature.
I can recognize how the emotions of whatever you've been through in that moment, you're not necessarily thinking in that way. A lot of people are not, or, they think that, by being extremely forthcoming, that means that they're going to be looked at with some sort of kinder eyes by investigators. That's not necessarily true. They're not your friends. They're trying to get to the bottom of something, or they're trying to figure out, they're also talking to a victim's family and, working with them and what have you. So, it's not cut and dry. And just because you cooperate doesn't mean you're going to get some type of favoritism.
Yeah, many people don't realize that self-defense claims can still lead to an arrest or charges before the full picture is understood. So why does that happen, and what does that process look like from there?
Well, it happens because, from a purely practical standpoint, it happens because you only have to have probable cause to arrest somebody. And until you flesh out exactly what happened, more often than not, if you've kind of honed in on somebody that might have a self-defense claim, then you probably have enough probable cause to arrest them for whatever assaultive behavior occurred. And that could be the whole spectrum of assaultive behavior, right? That doesn't necessarily have to include a dangerous weapon. And so because of that, you can arrest somebody, the state of North Carolina can arrest somebody and justify holding them for the purposes of their safety of the community, what the allegations are. Now that's kind of a dicey path for a prosecutor to go down, but it does come up, and a lot of times that happens while investigators are still waiting on forensics to come back, fully interviewing everyone around, because they feel like they have somebody that, it might be guilty of this, and the safest thing to do is to hold them and then figure out the rest later. That doesn't always happen that way, but there are many times it does, in fact, shake out that way.
For somebody who believes they acted in self-defense but is now under investigation, what should they understand about how quickly these situations can escalate and what steps help protect their rights?
Well, it can escalate very quickly, very, very quickly. Sometimes I feel like people are flippant about what they feel like is their ability or their right to use self-defense. And I say that as somebody that, I believe in your ability to do that. I have certainly seen a number of situations in my job where it is absolutely justified. But what they're faced with is something that, is probably a foreign aspect, because a lot of times people that are asserting self-defense, they haven't been exposed to something like this in the criminal justice system, or at least to this level, right? And you're kind of sitting there and you're thinking, I was justified in what I did, but you're still dealing with the personal, emotional aspects of it. So I know from our perspective, we try to get people involved with mental health professionals, right away, which can also be really beneficial later down the line. You're also looking at a situation where you still got other people out in the community that have formed their opinion. of what's going on. And that can be just as hard to deal with as, the legal aspect of it. So, it's a tough road to go down. I don't, wish it upon anybody to be in that scenario in any way, shape, or form on either side of it, because, at the end of the day, it's not like anybody wins. The person, even if you're asserting a valid claim of self-defense, usually is dealing with a lot of residual stuff for many, 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 many years. And then the person on the other side of it, you don't know, are they going to be permanently harmed if they were killed in the interaction? Then they still have a family, presumably, that's going to, be impacted by that. And so it's just they're difficult, terrible situations all the way around. And it's not like anyone leaves those courtrooms with a smiley, happy face.
Thank you for your insight today. That's it for today's episode of For the Record with Greenwood Law. If you'd like to learn more about attorney Dylan Greenwood and his work at Greenwood Law, please visit dwg-law.com. You'll find helpful resources about criminal defense in North Carolina, from state charges to federal charges. And we want to thank you for listening. Please review this again, share it with somebody if you know somebody who's in need of it, and come on back next week.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.